Get on the train before it leaves the station. The truth train is coming, gonna run them down, run them down.
Hey there, folks. How you doing? We're here today to talk about qualified immunity, folks, in the wake of everything that's happened with George Floyd. For those of you who remember Philando Castile, other cases where, cops acted in a way mainly because they felt like they could get away with it. They used exceeding force, but felt no reason not to use it because they always know that in the courts that there's never going to be consequences for it because of something called qualified immunity. And qualified immunity is something that the Supreme Court of the United States has taken upon itself to create. It's nullifying a piece of they're actually nullifying a piece of legislation from that was written in 1870, I think it is. That allowed Americans to be able to sue police officers who violated their constitutional rights. Well, SCOTUS has been cobbling together through their own case law this whole thing about qualified immunity and basically it's setting this really, really high bar that you have to meet in order to be able to civilly sue a police officer for violating your constitutional rights. Well, in light of the whole George Floyd situation, and like I said, for those of you who remember things like Philando Castile, for those of you who follow my channel and know about things like the Michael Funk situation in Neenah, Wisconsin, you know that there's instances out there where the cops do overstep. And unfortunately, I don't feel that all cops are bad. I'm not anti-cop. I'm not anti-law enforcement. But unfortunately, there are some bad apples out there who don't fear because they don't have any consequences to fear. They do really reprehensible things. It's unfortunate. I'm not saying, like I said, I want to repeat that. It's not all law enforcement officers, but there's enough of these individuals out there that are causing these terrible incidents basically to happen, and maybe they wouldn't if police officers knew that they might be held personally liable, civilly. If they knew that was actually a possibility, it might give them pause before they do something particularly heavy-handed, like firing first and asking questions later. So it's rough, it's tough, but what I have for you guys today is an article that's going to be explaining what's happening right now because of George Floyd, and as I said, other cases, like Philando Castile, and as I said, Michael Funk in Neenah, Wisconsin, Eagle Nation. It's this, things like this, and this current situation with George Floyd has caused all of this stuff to come up. And there are right now, if you guys remember, a couple days ago on my live, I showed you guys that Jerry Buting was retweeting Senator Amash. Senator Amash is looking to introduce legislation, a piece of legislation to abolish qualified immunity, basically, because legislation overrules the Supreme Court cobbling together case law. If Congress actually passes a piece of legislation, outlawing the qualified immunity, then the Supreme Court will not be able to use qualified immunity anymore. So that's why Senator Amash is taking that route. But there's potentially that route to change or remove qualified immunity through legislation. Then there's also what's happening right now in the article that I'm going to be showing you in a second, where there's 4 cases right now that are all petitioning for cert to the United States Supreme Court. They're looking to get rid of certiorari. These 4 cases all are cases where a judge originally found in the favor of the plaintiff who, basically not in favor of the cop, and then these cases were appealed to the the federal appeals court, the 3-judge panels. One of them's in the 6th Circuit, one is in the 11th Circuit, and then in those cases, the judgment was overturned, and the plaintiff's claim was thrown out. And so now all 4 of these cases are now petitioning the Supreme Court of the United States for cert at this time, when this whole thing is going on. So the Supreme Court could, by taking these cases, or some of these cases, the Supreme Court could relax some of the, they could set the bar a bit lower on qualified immunity. There's a number of things they could do here. So there's, like I say, these cases that are now getting ready to come in front of the Supreme Court are going to be interesting, and it's going to be interesting to see how this unfolds. So I wanted to call everybody's attention to it here today. Here we go. Let's get into the article. Supreme Court pressed to ease police immunity. Protesters and scholars and even justices have criticized the legal shield for officers, by David G. Savage. Amid nationwide protests over police killings, the Supreme Court is facing pressure to reconsider the legal immunity that often shields officers from being sued for using excessive force, including brutal arrests and shootings of innocent people in their homes. The High Court has been sharply criticized from the left and the right for rulings in the last decade that have made it nearly impossible for many victims of police brutality or wrongful shootings to sue the officers for violating their rights. Since police officers are rarely charged with a crime, the court created doctrine of qualified immunity from civil lawsuits. Has meant no redress for victims and little accountability for those who abuse their authority, according to the critics. In recent weeks, justices have been considering several appeals from victims, urging the court to reverse course and allow these claims to go before a jury. Lawyers behind the appeals say the images of Minneapolis police officer pressing his knee onto the neck of an unarmed black man who is handcuffed and gasping for breath should weigh on the justices. It makes for grim coincidence, said Jay Schweikert, a lawyer for the Cato Institute, which has waged a campaign against police immunity. The senseless violence committed by police officer Derek Chauvin and the stunning indifference of the officers standing by as George Floyd begged for his life is the product of our culture of near zero accountability for law enforcement. I expect the events of the past week will increase their sense of urgency because the justices are culpable for this doctrine that they have expounded. He noted that the issue has been taken up by protesters who carried signs that say abolish qualified immunity. He and others, there's also a senator trying to put a bill on the floor to do exactly that as well. He and others are encouraged because legal scholars have strongly disputed the doctrine of qualified immunity, and justices on the right and left have voiced doubts. Justices Clarence Thomas and Neil M. Gorsuch have questioned the doctrine because it was invented by judges, while Justices Sonia Sotomayor and Ruth Bader Ginsburg warned about its practical impact. The court's stance has sent an alarming signal to law enforcement officers and the public. It tells officers that they can shoot first and think later, Sotomayor said, dissenting in Casella v. Hughes in 2018. Without hearing arguments in the case, the justices overturned a lower court and tossed out an excessive force claim brought by a Tucson woman who was shot 4 times while standing in her front yard by an officer who had just arrived on the scene. The Tucson officer had no cause to make an arrest, and he faced no danger. Nonetheless, the justices ruled that the shooting victim could not sue the officer because there was no specific past ruling that clearly established it was unreasonable for an police officer to shoot someone in this particular circumstance. Because that's the way qualified immunity works. You can't sue a police officer in civil court unless there is a previous case that has pretty much the same exact facts and everything. You know, they have to be like nearly identical set of circumstances where you know, it's clearly established. It's a ridiculous bar that essentially can't be met. He and two other officers had responded to a call reporting that a woman had a large kitchen knife in her hand. The officer said he feared she might attack another woman standing nearby who turned out to be her roommate. So he decided to shoot her through the chain link fence. 3 years earlier, the justices tossed out an excessive force lawsuit brought by a mentally ill San Francisco woman who was shot in her private room in a group home. A social worker had reported Teresa Sheehan had not taken her medication, but when two officers tried to force their way into her room, she reacted angrily and told them to get out. A few minutes later, they pushed the door open again, and when Sheehan grabbed a bread knife, they shot her 5 times. The Supreme Court said they were entitled to immunity in San Francisco versus Sheehan, again, because there was not a clearly established past ruling that prohibited shooting a person under those circumstances. You understand, right? Because there wasn't a past case where that particular set of circumstances had been deemed wrong, basically these cases are all just getting dismissed and brushed under the rug. This legal shield gives officers breathing room to make reasonable but mistaken judgments. Justice Samuel A. Alito Jr. said, "It protects all but the plainly incompetent or those who knowingly violate the law. The Constitution is not blind to the fact that police officers are often forced to make split-second judgments," he added. Sheehan later won a settlement from the city based on a claim arising from the Americans with Disabilities Act. So she was able to eventually get something. But not everybody is able to use the American with Disabilities Act to, do that. Legal scholars say the justices have radically rewritten one of the nation's first and most important civil rights laws, one that gave all Americans the protection of the federal courts. Shortly after the Civil War, the Reconstruction Congress passed the Ku Klux Klan Act in 1871 to extend federal protection to African Americans and Union sympathizers in the South. They could not depend on local officials, the states or its courts to protect their rights. One provision of the new law said that any person who acts under color of any law and who deprives someone of any rights, privileges, or immunities secured by the Constitution shall be liable to the party injured in a suit in federal court. It includes no immunity for police or local local officials. In cases of police arrests, the constitutional right at issue would be the Fourth Amendment ban on unreasonable searches and seizures. Courts have long said that using excessive force to seize and hold a suspect violates the Fourth Amendment. An officer who wrongly kills someone could also be accused of violating the 14th Amendment, which says the state shall not deprive any person of life without due process of law. The 1871 law remains on the books and is known to lawyers as Section 1983 of the U.S. Code. But since the 1980s, the High Court has curbed this right to sue law. Instead, it has ruled government officials, including police officers, may not be sued unless it is beyond debate that their actions violated a clearly established precedent. In practice, however, judges are divided on what that means. Some courts have said the law is not clearly established unless a plaintiff can point to a past case with identical circumstances, even though most cases differ in some ways. Of course they do. They can't all be identical. The Supreme Court is being asked to reconsider this rule in a series of pending appeals. The case of Baxter versus Bracey began with Alexander Baxter, an African-American man and a burglary suspect, was chased by the police into the basement of a house in Nashville. An officer called out he would release a police dog unless Baxter gave up. The man sat with his hands raised over his head, but seconds after coming upon him, one officer unleashed a dog, which badly bit Baxter under his raised arms. Baxter sued for an unreasonable and excessive use of force. Officers Brad Bracey and Spencer Harris said the suit should be dismissed based on qualified immunity, but a federal judge refused. The police appealed to the U.S. Sixth Circuit Court of Appeals, and their case came before three President Trump appointees, Judges John Nalbandian, Amul Thapar, and John K. Bush. They ruled 3-0 to dismiss Baxter's claim. The officer's conduct, whether constitutional, did not violate any clearly established right, they said. Baxter does not point us to any case law suggesting that raising his hands on its own is enough to put police officer Harris on notice that a canine apprehension was unlawful in these circumstances. So you get that, what he just said there, right? You understand what he just said there? He just said that the universally recognized sign of giving up, putting your hands in the air, is not clearly established enough. In other words, in the courts. But, I mean, dude, since the beginning of time, practically, putting your hands up in the air was a sign of giving up, all right? I mean, anyways, well, maybe not to the beginning of time, but you know what I mean, right? It's like that is a pretty, really well-recognized sign of giving up. And so I find that reasoning shocking, to be perfectly honest. The American Civil Liberties Union urged the Supreme Court to hear Baxter's appeal. The decision throwing out his suit is an archetypal example of the problems with current qualified immunity doctrine, said Scott Mitchellman, an ACLU lawyer. Any reasonable officers in the shoes of Harris and Bracey would have known that unleashing a police dog against Baxter after he surrendered by raising his hands in the air was unconstitutionally excessive force. Amy Corbett, a Georgia woman, sued after her 10-year-old son was shot by Officer Michael Vickers after he came onto the property to arrest an unrelated suspect. For reasons that remain unclear, the officer fired shots twice at a family dog who posed no threat. Her son was lying on the ground, but the second shot hit him in the back of the knee. A federal judge refused to dismiss her suit, but the U.S. 11th Circuit Court of Appeals in Atlanta did so by a 2-1 vote. We hold that Vickers is entitled to qualified immunity because there was no clearly established law making it apparent to any reasonable officer in Vickers' shoes that his actions in firing at a dog and accidentally shooting the child would violate the Fourth Amendment, said Judges Lanier Anderson and President Carter appointee and Britt Grant, a Trump appointee. The court could announce an action on these appeals on Monday. So that's referring to the SCOTUS, the Supreme Court. So there's some appeals that are pending now, where these cases that they were just discussing are now appealing for a writ of certiorari with SCOTUS, so that SCOTUS can potentially do something about the current status of the qualified immunity doctrine, because this is what's getting talked about right now, folks. You saw the video I did the other night where Jerry was retweeting Senator Amash, who wants to put forth legislation to prevent the Supreme Court from being able to use this whole qualified immunity thing that they're cobbling together as they go along, and everything. So it's the whole qualified immunity thing is heavily under fire right now, thanks to Officer Chauvin. So that's kind of where we're at there. So I thought this was an interesting article that I wanted to show y'all. Okay, so there you go, folks. That's what's kind of happening here. over the next week. These cases, we may hear something by Monday in terms of these cases that are now petitioning for a writ of certiorari. So, this is the conversation that really needs to be focused on and taking place. It's qualified immunity is a big part of why Officer Chauvin felt he could do what he did, and felt that that there was nothing to prevent him. That he felt he just didn't have the same thing that the rest of us have, thinking about the consequences of our actions. He just didn't care about the consequences of his actions. And it's bad apples like Officer Chauvin that teach us. We have to keep our law enforcement accountable. We have the best way to love, as you heard Steve Moore, retired FBI agent himself, say it. The best way to love law enforcement is to keep them honest. And that's the truth. That is 100% the truth. And so it's watching cases like this and watching what SCOTUS is going to do with these cases, watching things like Senator Amash, who is looking to put through a piece of legislation to abolish the qualified immunity that the Supreme Court has been cobbling together since the 1980s, that is basically taken any sense of consequence away from police officers in the carrying out of their duties. Now, it's important to say, I mean, not all law enforcement officers are bad, but with a system like this that has no accountability, the bad apples can go as bad as they want, and they continue to give their own brothers a black eye. And hopefully, more and more, moving forward, more and more of the good officers will speak up and get involved when this kind of hokey BS is happening, and they won't just stand by and watch it happen. They'll start proactively, reporting fellow officers who are not following the rules, who are going to potentially at some point give the department a black eye because they are choosing to do things in a cavalier way, and that sort of stuff. So it's the qualified immunity, folks, is a big part of why this is happening. It's like I said, if there's no consequences, there's nothing to prevent particularly these bad apples from just going as bad as they want, because they know there's no consequences currently. So that's what we need to focus on in the future. I'm going to leave you with the words of retired FBI agent Steve Moore, telling you exactly what I just said in terms of how the best to love our law enforcement. All right, here we go.
I've worked with some good ones. I've worked with some bad ones. I've recommended prosecution for police officers. The FBI investigates police officers. As much as I love law enforcement, I think the best way to love law enforcement is to keep them honest and gain the people's trust and throw out the bad ones.